Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
All right, hold up. This is where things kick off. She's being charged with DWI and the breathalyzer is coming in hot. But 175 and then 181. That's more than double the legal limit in most states. Let's see how the judge handles this, because just having alcohol in your system doesn't always mean guilty. Probable cause still has to be solid.
On July 27th, 2024, at about 9:20 p.m., officers arrived on scene and observed two vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car. The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turns, a 3 out of 4 on the one-legged stand. The DIC was read and the defendant consented to a breath test.
Notice something strange here. The officer doesn't mention slurred speech, bloodshot eyes, or even the odor of alcohol. Those are major indicators in DWI cases. Without them, the defense might have a shot at poking holes in this probable cause. What do you think? Is a high breathalyzer enough on its own?
The first result was 0.175. Second result was 0.181.
All you said is there's an accident and she had missed one beer. Was there any slurred speech, bloodshot eyes, odor of alcohol?
Sure. It looks like we just have the car crash and the admission of.
Can you hear me?
Judge, can you hear me?
Yeah. Can you hear me?
Yeah, I'm here. Yes, sir. I'm sorry. I'm down in Galveston. Yes, sir. I'm here on Mrs. Morales.
Yeah. She's actually right in front of me right now, Michael.
I see it. Perfect. That's why I jumped on.
Have you heard PC yet?
No, sir.
All right. Do you mind reading it one more time?
Okay. Absolutely, Your Honor. On July 27th, 2024, at about 9:20 p.m., officers arrived on scene and observed two vehicles that had been involved in an accident. The witness stated she had been stopped at the light when she had been struck by the defendant's car.
The short answer.
The witness stated she saw the defendant to be the driver of the car that struck her. The defendant stated she had been downtown and was on her way home. She admitted to having one beer. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN, a 7 out of 8 on the walk and turn, a 3 out of 4 on the one-legged stand. The DIC was read and a breath test was given with the first result of 0.175 and a second result of 0.181.
I didn't hear anything about any kind of slurred speech, odor of alcohol.
Boom! No probable cause. Despite the breath test results, the judge tosses it. This is huge. It shows how critical it is for police to document all signs of impairment, not just rely on numbers, and the judge's warning, brutally real. One Uber or one coffin. Powerful moment.
Bloodshot eyes. I didn't hear any of that, Michael, so I'm just finding no probable cause.
Okay.
You know, Miss Morales, we have enough destruction on our streets, enough death from DWIs every single day. You know, just don't kill someone, please. If you're gonna drink, if you want to have 15 beers, 32 shots tequila, one button on your phone, $40 with an Uber will get you anywhere you want to go. Use it.
Sir.
Please.
Yes, sir. Thank you, Judge. I'll talk to you later.
Thanks, man.
Take care. Bye.
Your Honor. Ma'am, you're charged with theft by check. You're facing up to 6 months in jail and a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you, Your Honor. On June 30th, 2019, the defendant issued a check for $114 as payment for 4 containers of fruit, 3 containers of wine, 1 container of orange juice, 1 container of chips, 1 container of pizza, 3 containers of water, 2 containers of bread, and 1 container of beer. The bank returned the check marked NSF The defendant was identified through the Texas identification number, which was written on the front of the check.
So what was the total?
The total was for $114.97.
Okay. So, Ms. Rosas, Ms. Sanders, I'm going to find that there's sufficient probable cause to go forward with your case.
Now we're switching gears. Same courtroom, totally different vibe. Theft by check, $114 for groceries and booze, and the check bounced. Remember, even what seems like a small crime can spiral fast once you're in the system. This case shows how financial issues can become legal nightmares.
Ma'am, do you have the ability to hire a lawyer? Okay, I can have you fill out an application today. We'll take a look to see whether you qualify. I'm ordering you as a condition of your bond not to write any checks like these anymore. Do you understand?
Absolutely.
Okay, don't pick up any new cases. It's not going to go well for you, okay?
Yes, sir. Yes,
All right,
sir.
so Deputy Miranda's going to give you an application. I'm going to have you go to Jumay, sign a reset, and then we'll have you take your seat in the jury box, man. And then I'll appoint your lawyer. Ms. Williams, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Thank you. On April 16, 2025, in Harris County, Texas, an officer was dispatched to an assault call. The officer met with the complaining witness, who stated that he and the defendant are currently married. The complaining witness stated that he asked the defendant to be more respectful of him. The defendant became angry and started slapping complaining witness in the right shoulder several times, causing pain. The complaining witness pulled the vehicle over and the defendant punched him in the face, causing pain. The defendant then began to kick him in the head, causing pain and bleeding. The defendant admitted to kicking the complaining witness in self-defense.
And I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to have any contact with this person. Do you understand?
Yes.
There's a protective order that has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation of a protective order. It's one of the worst cases you can pick up. Do you have the ability to hire a lawyer, ma'am? Okay, I can have you fill out an application. We'll take a look to see whether you qualify. For now, I'm going to have you go to Jumay, sign a reset. We'll have you take your seat in the jury box. I'm going to generate bond conditions for you to sign. Do not leave until you sign them, otherwise a warrant will issue. Please. So can you file no contact, no weapons?
Yes, sir.
Okay, so Stuart.
Stuart, yes. So this is a number of cases right now, and
Where is Mr. Stewart?
Mr. Stewart is in the back. He has shown up today. He's on bonding. He says he's fulfilled all the conditions that whenever he was last before you, you asked him to fulfill.
Come up, Mr. Stewart. I'm not happy with you, Mr. Stewart.
Count them 8 open cases. Stewart's legal rap sheet is basically a novel at this point. And the judge is done playing games. Too much drama, he says. Honestly, same. But here's a tip for viewers: when a judge starts talking ankle monitors and sky-high bonds, you're officially in legal deep water.
I'm an ankle monitor, so I know where you are at all times. I'm ordering you not to use alcohol or illegal drugs. If I find that you're using, it's not going to go well for you. And I'm telling you now, the next time you pick up another case, you're going to take off. I'm going to make your bond so high, you're going to flip. Do you understand? You have 1, 2, 3, 4, 5, 6, 7, all of them. These cases are 408 days old. How long have you been on?
I have been on for less than a month.
Okay, I'm going to give you one setting to get ready, and then I'm going to set these cases for trial. He's way too much drama for him. He's got an unlawful carrying, 3 evading arrests, injury to the elderly, 2 aggravated assaults. It's just way too much drama.
I'd move on them today if it were not for the fact that there are felonies entangled with each of these misdemeanors.
None of them have any kind of relation. Our cases are all prior to the felony cases. So I don't think that they have any relation. Show me that they are. So hold on. I don't want you to talk here in front.
It's okay.
Just something you need to talk about, but
Next time we'll be ready, trial or not.
so
Okay.
just, do you have offers on these cases, please? Anthony, I'd like Mr. Stewart tested within a week, please.
We have a couple who were eventually withdrawn. I'm scrolling through the cases here.
Okay, well, regardless, if you can, please put an offer at least 2 weeks prior to the next setting so that they can get ready. It is your responsibility between now and the next setting to get with the lawyer that we've given you to go through all the evidence to see what you want to do. I'm not waiting. There's way too much drama. Your cases are too old, and I'm not waiting for the felony cases to drop. Do you understand? I will give you 30 days. At that time, it's plea or trial. Okay, Colin, thanks.
Thanks, Judge.
So he needs to meet with the pretrial before he leaves.
Yes. Yeah, we'll do this conditions.
You want him in the jury or back? You want him in jury box or back?
That's fine, just don't leave until they've met.
Judge, curfew will remain in Mr. Stewart as well, right? It's 9 p.m. to 6 a.m.
Yeah.
Yes, and that's something with the.
Hi, Blossom,
Yes, Your Honor. I have an arraignment with counsel.
are you ready?
Yes, sir. Mr. Menchu? Pedro?
Didn't you?
Menchu, that's what he said.
Pedro.
Pedro,
Wait, who?
Pedro Menchu, he said?
Pedro
Does he have a-
Menchu.
Oh, Yax. Oh, Y-A-X maybe. Pedro Yax Menchu. Y-A-X.
I'm showing he's in jail. Blossom, I'm showing he's in jail. He's in jail? Deputy, you going?
Sorry about that.
So
Nomás escuché
has he made bond on this
Usted
case?
salió en fianza.
As far as I can tell, he's made a
I
bond.
don't even show him on doc. Do you show?
Neither did she, but he's, apparently somebody told him to be here and
I'd say-
told us to.
You're gonna PR bond for a standing. He's set for tomorrow, yeah. He's on dock.
Set for tomorrow.
Well,
Oh,
I don't know what happened. I don't show him on ours being
So
set. for-
Roxanne, can I give you this cause number? Because it's on for tomorrow. It's not on for today. Ready? 256-0488. It's a DWI. For Pedro
Ustedes
Jesus
ven
Yax
Jesús.
Menchu.
Menchu? Yes, exactly.
You were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot